All right, so picture this. You're a business owner, you're hustling, you're making things happen, right? You're about to open the doors to your new restaurant, that dream you've been working towards forever.
Yeah.
And then, bam, your landlord hits you with some unexpected changes to your lease agreement.
Oh, wow.
Or maybe you're just about to close on this amazing commercial property, perfect for expanding your business, and then suddenly you run into some crazy zoning issue that just puts everything on hold.
Yeah, I could see how that would be a problem.
These aren't just, hypothetical situations. These are real headaches that business owners face all the time, and they can really derail things.
Absolutely. And you know what's really important for business owners to understand is that these commercial real estate legal disputes, they're not some like rare occurrence.
Right.
They happen more often than you'd think.
Yeah.
And for a lot of businesses, especially smaller ones, or those operating on tight margins dealing with these disputes, it's like navigating a minefield blindfolded.
It's really overwhelming.
Yeah, exactly. So knowing the ins and outs and having the right strategies in place is absolutely crucial.
Couldn't agree more. So for today's deep dive, we've gathered a really interesting mix of resources for you. We've got insights from legal blogs, the folks who are dealing with these issues every single day.
Right on the front lines.
Exactly. We've also got some problem-solving methodologies because at the end of the day, that's what navigating these disputes is all about, finding solutions.
Absolutely.
And we've even looked at things from a business finance perspective to understand, the real-world impact of these legal challenges.
Yeah, the bottom line.
Exactly. Our goal today is to equip you with the knowledge and the strategies you need to confidently deal with these commercial real estate legal disputes, and most importantly, protect your business.
So let's dive in.
Hmm.
I think one of the first things to grasp is just how many different shapes these disputes can take.
Yeah.
I mean, the most obvious one is the lease agreement itself.
Yeah, that seems to be a major pain point.
It's a breeding ground for disagreements. But it goes beyond that.
Yeah.
We're talking about situations where someone just doesn't uphold their end of the bargain.
Right, a breach of contract.
Exactly, a breach of contract, meaning one party fails to fulfill their obligations.
Right, and it's not always about, someone intentionally breaking a promise. Sometimes it's just a misunderstanding or unforeseen circumstances.
Absolutely.
And you mentioned zoning, which can be a huge roadblock. You might have a specific plan for a property, but local regulations might say no way.
Exactly.
And then you've got environmental issues. Maybe there's contamination or hazardous materials discovered that can really throw a wrench in things.
A huge wrench.
And of course, you can't forget about the more straightforward disputes like who's responsible when a property gets damaged.
Right.
So many things to consider.
It's important to remember that these legal battles, they're not always a simple landlord versus tenant scenario.
That's interesting.
You could find yourself in a dispute with co-owners of a property, with neighboring businesses over things like easements, or even with government agencies at the local, state, or federal level, regarding permits or compliance.
Right.
It's a much bigger and more complex landscape than people realize.
It's like you're playing a game of chess and you can't see all the pieces on the board.
Exactly. You need to think several steps ahead, anticipate potential problems, and plan your strategy proactively instead of just reacting when something blows up.
Proactive versus reactive, always the best approach.
Absolutely.
Yeah.
Now let's talk about one of the most common battlegrounds in commercial real estate, the lease agreement.
Well, lease disputes, those seem to be everywhere.
They are incredibly prevalent, and they can really make or break a business.
For sure. So let's say you're the owner of this cool little boutique, right? And you just signed a lease for a great spot in a busy shopping district.
Prime location.
Exactly. You're excited, you're ready to make it big. But then a few months in, you start noticing some serious water damage after a heavy rainstorm. And suddenly you're like, wait, who's supposed to fix this? Is it the landlord or is it me as the tenant? And the answer, it's usually hidden somewhere in the fine print of the lease agreement.
It's all about the details in the lease. And those details can be incredibly complex and confusing, especially for someone who's not a legal expert.
Right. So many clauses and jargon.
Exactly. Business owners need to really scrutinize that lease and ask some important questions right from the get-go.
Like what kind of questions?
Well, for starters, what are the exact terms regarding rent increases? When and how can the rent go up? Are there any clauses about common area maintenance fees, and could those costs suddenly spike?
Right.
And this is crucial. Who's responsible for handling different types of repairs, from a leaky faucet to major structural issues with the building?
Right, because those costs can add up quickly.
Absolutely. We actually came across a real-life example of this in our research.
Oh, tell me about it.
So there was this coffee shop owner in New York City. They thought they had reviewed their lease carefully. But there was this tiny little clause buried deep in the document about foundation repairs being the tenant's responsibility.
Oh, no.
And then what happened? A major structural problem with the building's foundation emerged, and they got hit with a bill for tens of thousands of dollars in repairs.
Wow. Completely unexpected.
Totally blindsided them, and it almost put them out of business.
That's a nightmare scenario.
Hmm.
So what can business owners do to avoid these kinds of lease-related disasters?
The most important thing is to read every single word of the lease agreement. Don't skim it. Don't just glance at the rent amount and the dates.
Right, take your time.
Understand what every sentence, every paragraph actually means and what the implications are. Pay close attention to clauses about rent increases, maintenance responsibilities, and any potential fees or charges.
And if anything is unclear, don't be shy about asking questions, right?
Absolutely. If there's any legal jargon you don't understand, ask for clarification. Demand clear explanations of all the terms, especially when it comes to money and repairs.
Make sure everything is crystal clear before you sign anything.
And once you're in the lease, keep those lines of communication open with your landlord.
Right. Build a good relationship.
Exactly.
Di-
Document any concerns, requests, or agreements in writings so you have a paper trail if a disagreement pops up later.
That's a great tip. And one of the most consistent pieces of advice we saw across all our legal sources was to get a lawyer involved.
Oh, yeah, absolutely.
Specifically, a lawyer who specializes in commercial real estate law to review that lease agreement before you sign on the dotted line.
Think of it like this. If you had a serious medical issue, you wouldn't try to diagnose and treat yourself. You'd go to a doctor, right?
Makes sense.
A commercial real estate attorney. They're the experts. They can spot potential risks and problems in a lease that you as a business owner might miss.
Right. They have the trained eye.
Exactly. And they can also negotiate better terms for you, potentially saving you tons of headaches and money down the road.
It's like having a personal trainer, but for your business's legal health.
Exactly. They can help you build a solid legal foundation and avoid those potentially devastating legal injuries.
So now let's move on from leases and talk about another big area where commercial real estate legal issues come up: contractual agreements.
Right.
These aren't just limited to the lease you sign for your space. They can involve all sorts of agreements related to commercial property.
Like what?
Well, think about purchase and sale agreements, contracts with construction companies for renovations, even agreements with vendors and service providers.
Okay, through a wide range.
Exactly. And the disputes often arise when someone doesn't fulfill their obligations as outlined in the contract.
Right, a breach of contract.
Exactly. Or sometimes it's just a plain misunderstanding of the terms.
Misunderstandings can definitely happen, especially in these complex commercial transactions where there's a lot of money at stake.
Right, high stakes.
For example, when you're buying a commercial property, the purchase agreement might have certain conditions or contingencies that aren't so obvious.
Such as?
Well, they could include things like requirements for specific environmental assessments to be done, or the existence of zoning restrictions that could really limit how you can use the property after you buy it.
Gotcha, those hidden surprises.
Exactly. And we found this really cautionary tale about a developer in California.
Oh, what happened?
So this developer was all set to buy this big piece of land to build a new housing development. The purchase contract seemed pretty standard, but it didn't properly address some recent changes to local zoning laws.
Oh, that's not good.
Nope. So after the sale went through, the developer got sued by the local authorities and ended up losing millions of dollars because their planned development was no longer allowed under the new zoning rules.
Wow, all because of an oversight in the contract.
A seemingly small oversight, but with massive consequences.
So how can businesses protect themselves when it comes to these broader commercial real estate contracts?
Well, the first and most crucial step is to make sure that every single term and condition of the agreement is spelled out clearly and understood by everyone involved.
No room for ambiguity.
None at all. Be very specific with the language. Don't leave anything open to interpretation.
Right, and don't be afraid to negotiate those terms.
Absolutely. Don't just accept the first draft that's presented to you. Push back, discuss any concerns, and insist on language that accurately reflects what everyone is agreeing to.
Be your own advocate.
Exactly.
Yeah.
And just like with leases, if you have any doubts about a contract, bring in a lawyer.
Get that expert advice.
It's much better to invest in legal review up front than to deal with a messy and expensive legal dispute later on.
An ounce of prevention is worth a pound of cure.
And it's also a smart move to review and update your standard contracts periodically as your business changes or as laws and regulations change.
To keep them current.
Exactly. What might have been fine a few years ago might not be sufficient today.
It's like updating the software on your computer or your phone.
It's exactly. You do it to get rid of bugs and improve performance and make sure you have the latest security features. Your contracts need the same kind of attention.
Makes sense. Now let's shift gears and talk about another big category of legal disputes in commercial real estate zoning and land use regulations.
Right. Zoning, this can be a tricky area.
Yeah, because it often involves navigating a complex web of local laws, ordinances, and bureaucratic procedures.
It's not always straightforward.
Not at all. And these disputes can pop up when local zoning laws change, or even when there's a disagreement about how a property is being used according to the current zoning rules.
So imagine this. You have a small manufacturing company that's been operating in an industrial zone for years.
Okay.
And then the local government decides to rezone that area to allow for more mixed-use development, like residential properties.
The rules of the game change.
Exactly. And now the manufacturing company's plans to expand their operations are suddenly limited because their property no longer fits the new zoning rules for that type of industrial use.
Wow, so even if you're following the rules, things can change unexpectedly.
Absolutely. And we even saw a high-profile example of this in Silicon Valley.
Oh, really? Tell me more.
So this major tech company with tons of resources and lawyers wanted to build a new corporate campus.
Okay, makes sense.
But they faced huge pushback from the community.
Really? Why?
Well, a big part of it was about local zoning laws, environmental concerns, and worries about the strain the development would put on local infrastructure.
So even big companies with big legal teams can run into zoning roadblocks.
Exactly. It highlights how significant and impactful these zoning regulations can be.
So for business owners who are worried about potential zoning issues, what should they do?
The most important thing is to stay informed about local zoning laws and land use regulations that could affect your business or property.
Right, don't bury your head in the sand.
Exactly. These laws can change, and they often do sometimes without much notice. Make it a habit to check for updates and understand how any changes might impact your plans.
Good advice. And what about engaging with the community?
That's a great point. Getting involved with community stakeholders early on can be a huge help.
How so?
Well, if you're planning a big development or expansion project, proactively building relationships with neighbors, community groups, and residents, and being transparent about your plans can often prevent disputes from turning into legal battles.
So build those bridges early on.
Exactly.
Yeah.
And working closely with local authorities is also key.
Right. Don't see them as the enemy.
Exactly.
Okay.
See them as a resource.
Yeah.
They can provide valuable information and guidance on zoning regulations. Build a rapport with them and get their input early in the process.
Collaboration over conflict.
And if you're dealing with a complex or potentially controversial zoning issue, don't hesitate to bring in expert consultants.
Call in the big guns.
Exactly. Find specialists in land use law and urban planning. They have the knowledge, the experience, and the connections to navigate these intricate regulations effectively.
They're like your business's GPS for zoning.
Precisely. They can help you map out the best course, avoid roadblocks, and reach your goals without getting stuck in legal quicksand.
So we've talked about different types of commercial real estate disputes. Now let's talk about how to actually resolve them when they happen.
Right, because even with the best planning, disagreements and disputes can still arise.
It's the nature of business.
So what are some effective ways for businesses to tackle these challenges and find solutions?
I'm all ears.
Well, one of the most valuable approaches is to explore alternative dispute resolution methods, often called ADR.
ADR.
Yep, things like mediation and arbitration.
Okay.
These methods can be a lot more efficient and cost-effective than going through the traditional court system.
So less time and less money spent on legal battles.
Exactly.
Can you explain the difference between mediation and arbitration?
Sure. In mediation, you have a neutral third party called a mediator who helps the disputing parties talk things through and negotiate.
So the mediator is like a referee.
Kind of, but they don't make the decisions. Their role is to facilitate communication, help everyone understand each other's perspectives, and ultimately reach a solution that works for everyone.
Gotcha.
In arbitration, on the other hand, you have an arbitrator who acts more like a private judge.
So they have more authority.
Right. They hear both sides of the story and then issue a binding decision that everyone has to follow.
So both mediation and arbitration offer a way to resolve disputes outside of the courtroom.
Exactly. And that can be a huge advantage.
Saves time, money, and stress.
Absolutely. And these alternative methods often allow for more creative and customized solutions that might not be possible in a court setting.
That makes sense.
Plus, they can help preserve business relationships, which can be really important.
Right, you don't want to burn bridges.
Exactly. Another benefit of mediation specifically is that it's confidential, which can be crucial for businesses that want to keep disputes out of the public eye.
Discretion is key sometimes.
Absolutely. Another piece of advice that came up a lot is to have your contracts reviewed by a lawyer, not just to prevent disputes, but also to include clauses that outline how you want to handle disputes if they do happen.
So plan ahead for the what-ifs.
It's exactly. A well-written contract can specify mediation or arbitration as the first steps in resolving disagreements, which can make the whole process smoother and less costly.
That's smart thinking. And it's interesting how this ties into general problem-solving strategies.
Oh, how so?
Well, even in a legal dispute, the basic steps are often the same. Identify the root causes of the problem, brainstorm potential solutions, and then choose the most effective and mutually agreeable way forward.
You're absolutely right. Taking a strategic and structured approach, even when you're dealing with a legal issue, can make a big difference in the outcome.
We actually found a great real-life example that shows the power of mediation in resolving a commercial real estate dispute.
Oh, tell me about it.
So this was a case where a landlord and a tenant were at a standstill over unpaid rent.
Classic dispute.
Instead of jumping straight to eviction and a long legal battle, they agreed to try mediation.
Good for them.
And what happened?
Well, through the mediation process, they were able to have an open and honest conversation about the tenant's financial struggles and the landlord's concerns about lost income.
Right, so both sides could be heard.
Exactly. The mediator helped them explore different options, and they came up with an agreement where the tenant would make smaller payments for a while and then gradually catch up on the back rent.
So a win-win situation.
Exactly. It saved both sides a lot of money and stress. And most importantly, they were able to maintain their business relationship.
That's a great outcome. It's like resolving a family disagreement, where the goal is to find a solution everyone can live with, even if it's not exactly what they wanted at first.
Exactly.
And it really highlights that problem-solving approach of finding a solution that benefits everyone, not just one side.
Absolutely. So as we wrap up this deep dive, what are the key takeaways for business owners dealing with commercial real estate challenges?
I think it comes down to a few key principles. First, careful planning is essential. You have to understand the legal landscape, even if it's just the basics. And as we've said over and over again, getting all leases and contracts thoroughly reviewed before you sign anything is crucial.
Couldn't agree more.
You also need to stay up to date on local zoning laws and regulations that could affect your business.
Knowledge is power.
Exactly. And keep those lines of communication open with your landlords, tenants, and local authorities.
Build those relationships.
And if disputes do arise, consider alternative dispute resolution methods like mediation or arbitration. They can be a much better option than traditional litigation.
Save you time, money, and heartache.
By taking these steps, businesses can reduce their risk of getting caught in costly and time-consuming legal battles.
And focus on what really matters growing their business.
Exactly. It's all about having those systems in place and even thinking about outsourcing certain tasks like legal review to make sure things run smoothly.
It makes sense.
So as you navigate the world of commercial real estate, keep these insights in mind.
Good advice.
And here's a final thought for you to ponder. We've talked about legal frameworks and contracts, but what about building strong collaborative relationships with your landlords, tenants, and local authorities?
Interesting.
How can those relationships help prevent disputes from happening in the first place? Something to think about.
Definitely food for thought.
Thanks for joining us for this deep dive. We'll see you next time.
See ya.